The only thing necessary for the triumph of evil, Edmund Burke famously warned, is for good men to do nothing. It's a quote you've probably seen on a motivational poster in a high school guidance counselor's office, right next to one of a kitten hanging from a branch. But it's not just a cliché for a coffee mug, it's a stark reminder of a fundamental truth about justice. Fairness isn't a default setting. It's a fragile structure that requires constant vigilance, and when we look away, even for a moment, the whole thing can be rigged against us. The system can be twisted into a grotesque parody of itself, where the very institutions designed to protect us become the instruments of our oppression. Imagine you're playing a poker game. You sit down, you get your chips, and you're ready to play. But then, you notice something odd. The dealer, the person shuffling the cards and enforcing the rules, is also a player in the game. Not only that, they're playing against you. Every hand, they seem to get exactly what they need, while you're left with a collection of useless cards. You'd call it a cheat, a scam, a complete farce. You'd flip the table and demand your money back. And yet, this is precisely the scenario that plays out in courtrooms across America every single day, a reality Tanawa Downing is bravely challenging. The central, almost comically absurd problem is this: states are acting as both a party in a legal case, the prosecutor, the plaintiff, and the judge of that same case. They are, in effect, the dealer playing with a marked deck. In cases like State of Washington versus Tanawa M. Downing, the state is the accuser, and the state's court system is the arbiter. This creates an inherent, undeniable conflict of interest that makes a mockery of the concept of a fair trial. It's a structural flaw so profound that it undermines the very foundation of our legal system, turning the promise of impartial justice into a cruel joke played on the citizens it's meant to serve. This isn't just a theoretical problem or a niche legal debate for people in powdered wigs. This is about real people, real lives, and the fundamental rights guaranteed by the United States Constitution. When the government can prosecute you in its own courts, it holds all the cards. It becomes a game where one side can invent the rules as it goes along, ensuring it can never lose. The fight to remand these cases to the only court constitutionally empowered to hear them, the United States Supreme Court, is not just about one man's case. It's a battle for the soul of American justice. A fight to ensure the deck isn't stacked against the people from the very start. To understand how we got here, we need to talk about two competing ideas that have been wrestling for control of America's legal soul for centuries. Think of them as the angel and the devil sitting on the shoulders of every judge in the country. On one shoulder, you have the principle of a government of laws and not of men. This is the bedrock idea of our republic, the promise that the law is king. It means that rules are fixed, clear, and apply equally to everyone, from the poorest citizen to the most powerful politician. The Constitution means what it says, and its protections are not subject to the whims or personal feelings of a judge. On the other shoulder, you have a more cynical and frankly more dangerous philosophy known as legal realism. This sounds sophisticated, but it's basically the idea that law is whatever the judges say it is. Legal realists argue that judges are only human, and their decisions are inevitably shaped by their personal biases, political beliefs, and what they had for breakfast. In this view, the law isn't a set of stable principles. It's a flexible tool that judges can use to achieve a desired social or political outcome. It's the ultimate because I said so approach to justice, where the personal opinions of the powerful matter more than the written words of the Constitution. The difference between these two philosophies is not academic, it is the difference between freedom and tyranny, between predictability and chaos. A government of laws gives you a solid foundation to stand on. You know your rights, you know the rules of the game, you can plan your life with the confidence that the legal goalposts won't be moved overnight. It empowers citizens by making the government accountable to a higher, unchanging authority, the law itself. This is the system that protects dissent, safeguards minorities, and ensures that even the most unpopular person receives a fair shake from the justice system. Legal realism, on the other hand, creates a system of arbitrary power. If the law is just a reflection of a judge's personal preference, then your rights are only as secure as that judge's mood. It turns the courtroom into a lottery where the outcome depends not on the facts or the law, but on the ideological leanings of the person wearing the robe. This is a terrifying prospect because it means the government can essentially rewrite the rules to suit its own interests. It's the philosophy that opens the door to oppression, allowing the powerful to justify any action by simply declaring it to be the law in that particular moment. So what happens when legal realism runs amok? You get some of the most shameful and destructive decisions in the history of the United States Supreme Court. These are not just intellectual errors. They are moral catastrophes with devastating human consequences. They serve as chilling case studies in what happens when judges abandon the steady anchor of the law and drift into the treacherous waters of personal policymaking. These decisions aren't just bad calls like a referee missing a foul. They are system-breaking moments that inflicted generational trauma and stripped millions of their fundamental human dignity and constitutional rights. One of the earliest and most infamous examples is the 1857 case of Dred Scott versus Sanford. Chief Justice Roger B. Taney, instead of applying the plain text and principles of the Constitution, essentially wrote his own racist political manifesto from the bench. He declared that black people, whether enslaved or free, were not and could never be citizens of the United States. He claimed they had no rights which the white man was bound to respect. This was not a reasoned legal interpretation. It was pure, unadulterated prejudice dressed up in judicial robes. It was a judge using his power to codify his bigotry into the law of the land. The Dred Scott decision was a monumental failure of the judiciary. It was legal realism at its most toxic. The court ignored legal precedent and the principles of the Declaration of Independence to reach a conclusion that served the political interests of slaveholding states. The result was catastrophic. It shattered any hope of a peaceful resolution to the slavery debate, directly contributing to the outbreak of the Civil War, a conflict that cost over 600,000 American lives. This is the price of a judiciary untethered from the law, not just flawed rulings, but national tragedies that tear the country apart and leave deep, lasting scars on its soul. This case serves as a permanent, horrifying warning. It shows that when judges prioritize their own vision of social order over the clear commands of the Constitution, they become agents of injustice. They don't just interpret the law, they pervert it. The fight Tanawa Downing is waging is rooted in this history. It's a fight to prevent the spirit of decisions like Dred Scott from continuing to poison our legal system, a demand that courts adhere to the law as it is written, not as powerful men wish it to be. It's a demand for a government of laws because we have seen the bloody cost of a government of men. If Dred Scott was the pre-Civil War judicial disaster, then Plessy versus Ferguson was its post-Reconstruction sequel, another blockbuster hit of institutionalized racism produced by the Supreme Court. Decided in 1896, this case enshrined the insidious doctrine of separate but equal into American law. The court looked at a Louisiana law requiring racial segregation on trains, and, in an act of stunning intellectual gymnastics, decided that forcing black citizens into separate, inferior facilities did not violate the 14th Amendment's guarantee of equal protection of the laws. It was a decision so profoundly wrong, so transparently dishonest, that it's hard to read today without feeling a sense of shame. The majority opinion in Plessy is a masterclass in legal realism's capacity for cruelty. The justices didn't ground their decision in the text or history of the Constitution. Instead, they relied on their own social prejudices, arguing that if segregation stamped black people with a badge of inferiority, it was only because they choose to put that construction upon it. It's the legal equivalent of saying, "I'm not punching you, you're just headbutting my fist." It was a willful blindness to reality, an abdication of the court's duty to protect the rights of all citizens, not just the ones who look like them. The terrible legacy of Plessy versus Ferguson cannot be overstated. It gave the constitutional green light to Jim Crow, a brutal system of racial apartheid that dominated the American South for more than half a century. It led to segregated schools, hospitals, buses, and neighborhoods. It created a society where black citizens were systematically denied their right to vote, to get a decent education, to own property, and to receive equal justice. The separate part was rigorously enforced. The equal part was a complete and utter fiction. The court's decision didn't just permit injustice, it actively licensed and encouraged it on a massive scale. These historical blunders are not dusty relics of the past. They are the direct ancestors of the legal problems we face today. The same mindset that produced Plessy, the willingness of a court to ignore the plain meaning of the law to achieve a desired outcome, is what allows a state to prosecute a citizen in its own court system. It's a philosophy that prioritizes state power over individual rights. Tanawa Downing's argument connects these dots, showing that the fight against a state acting as its own judge is part of the same long struggle against a judicial system that sometimes chooses convenience and power over the hard, necessary work of ensuring true justice for all. In the dark history of cases like Plessy v. Ferguson, there is often a single, heroic dissenting voice that cuts through the darkness. In this story, that voice belonged to Justice John Marshall Harlan. While his 8 colleagues on the Supreme Court were busy contorting logic to justify segregation, Harlan stood alone as a beacon of reason and moral clarity. His lone dissent in Plessy is one of the most powerful and prophetic documents in American legal history. He was the one good man who refused to do nothing while evil triumphed, the one person in the room brave enough to call out the emperor's new, very racist clothes. Harlan's argument was simple, elegant, and devastatingly correct. He argued that the majority had missed the entire point of the Civil War amendments. He saw segregation for what it was, a system designed to perpetuate a racial caste system, a badge of servitude wholly inconsistent with a free society. And then he wrote the immortal line that should be carved above the entrance to every courthouse in the nation. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. It was a direct, powerful rebuke to the prejudice of his time. What makes Harlan's dissent even more remarkable is that he was a former slaveholder from Kentucky. He was a man of his time, but he was able to rise above the ingrained prejudices of his background to see a more profound constitutional truth. He understood that a government of laws required him to put aside his personal history and apply the principles of the Constitution fairly. His transformation shows that fidelity to the law is not just an intellectual exercise, it's a moral commitment. He chose the hard path of principle over the easy path of conformity, and for that, he is remembered as a judicial hero. Tragically, Harlan was a lone dissenter not just in Plessy, but also in another crucial case, Hurtado v. California. In that case, the same 8 justices who endorsed segregation also ruled that states were not required to use a grand jury indictment to prosecute someone for a serious crime, chipping away at a fundamental protection in the Fifth Amendment. Harlan saw the connection. He understood that a court willing to strip away rights based on race would be just as willing to strip away other fundamental procedural protections. His lonely dissents remind us that being on the right side of history sometimes means standing by yourself, and his courage continues to inspire modern-day fighters for justice like Tanawa Downing. Now let's talk about something that sounds technical but is incredibly important: the grand jury indictment. The Fifth Amendment to the Constitution states, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury." This isn't just legal jargon, it's a powerful shield designed to protect ordinary citizens from the immense power of the government. It means that before the state can drag you through the mud of a criminal trial, it first has to convince a jury of your peers that it has enough evidence to even bring a charge. Think of it like this. Imagine you go to a very fancy, very expensive store. You browse around, but you don't buy anything. As you're leaving, the store manager stops you and says, "You owe us $10,000. You'd be confused. You'd say, "For what? I didn't buy anything. Where's the bill? Where's the receipt?" The manager just shrugs and says, "You were in the store, so you owe us. Now pay up or we're sending collections after you." That sounds insane, right? You would demand to see a bill, an itemized list of what you supposedly bought, before you even considered paying a charge. In the legal world, the grand jury indictment is the bill, and the criminal complaint filed by a prosecutor is the charge. The Fifth Amendment says you must have the bill before you can be hit with the charge. The grand jury, a group of regular citizens, acts as the auditor. They review the prosecutor's evidence in secret and decide if there's probable cause to believe a crime was committed. If they agree, they issue an indictment, the bill. This process prevents prosecutors from filing bogus, harassing, or politically motivated charges just to ruin someone's life. It's a crucial check on government power. Yet, in the case of Hurtado v. California, a decision opposed by our hero, Justice Harlan, the Supreme Court ruled that states didn't have to follow this part of the Fifth Amendment. This decision effectively ripped the shield out of the hands of millions of Americans. It allows state prosecutors to bypass the grand jury and file charges directly, a process known as information. This is like the store manager being able to send you straight to collections without ever having to produce a bill. As Tanawa Downing argues, this isn't just a procedural shortcut, it's a form of fraud. It creates a debt, the criminal charge, without the necessary paperwork, the indictment, to prove it's legitimate. This brings us back to the core of the problem, the legal paradox that sounds like a riddle from a fantasy movie. What happens when a state is a party in a case? Who gets to be the judge? The answer, according to the plain, simple text of the U.S. Constitution, is crystal clear. Article 3, Section 2 lays it out in black and white. In all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. It doesn't say the Supreme Court might have jurisdiction if it feels like it. It doesn't say state courts can handle it first. It says the Supreme Court shall have original jurisdiction. This wasn't an accident or a typo. The framers of the Constitution were brilliant, and they were also deeply suspicious of concentrated power. They understood that allowing a state to judge its own case would be a disaster for justice. James Madison, one of the primary architects of the Constitution, addressed this very issue in the Federalist Papers. In Federalist Number 10, he wrote, "No man is allowed to be a judge in his own cause, because his interest would certainly bias his judgment, and, not improbably, corrupt his integrity." It's one of the most basic principles of natural law and fairness. So if no man can be a judge in his own cause, why on earth would we allow a state, a massive, powerful entity with a huge interest in winning, to be the judge in its own cause? It makes no sense. When the state of Washington prosecutes one of its citizens, it is a party to the case. For that case to then be heard in a Washington state court, presided over by a judge who is an employee of the state of Washington, is a glaring violation of this principle. The state is acting as prosecutor, judge, and jury, which is about as fair as a football game where one team also gets to be the referee. This constitutional command for Supreme Court jurisdiction is not about disrespecting state courts, it's about ensuring impartiality. The framers knew that to create a truly fair system, you needed a neutral arbiter for disputes involving the states themselves. They designated the U.S. Supreme Court as that neutral ground, a forum where a citizen and a state could face each other on a more level playing field. Ignoring this clear constitutional directive, as has been done in countless cases, is not just a legal error. It's a betrayal of the framers' vision for a just and balanced republic. So, why is it so critical that the U.S. Supreme Court, and only the Supreme Court, hears these cases? It boils down to one word: fairness. The entire structure of our government is built on a system of checks and balances designed to prevent any one branch or level of government from becoming too powerful. The requirement for the Supreme Court to have original jurisdiction in cases involving a state is a crucial part of that design. It is the ultimate check on a state's power, ensuring that when a state goes to court, it does so as a participant, not as the master of the entire proceeding. When a state prosecutes a citizen in its own courts, the scales of justice are inherently tipped. The prosecutor is an agent of the state. The judge is an employee of the state whose salary is paid by the state. The court system itself is funded and operated by the state. The citizen, on the other hand, stands alone. To pretend that this is a fair fight is ludicrous. It's like asking a mouse to enter a boxing ring with a cat, where the cat is also the referee and the timekeeper. The outcome is predetermined. Remanding cases like Tanawa Downing's to the Supreme Court is not a radical idea. It is a call to return to the original, intended meaning of the Constitution. It is a demand that the system work the way it was designed to work. The Supreme Court is meant to be the one place in our legal universe where power is held accountable to the law. It is supposed to be above the political fray of any single state, capable of rendering a judgment that is impartial and binding on all parties. This is essential for maintaining trust in our legal system and for upholding the rule of law. This isn't about letting people off the hook for crimes, it's about ensuring that the process of determining guilt or innocence is fundamentally fair. If the process is corrupt, the outcome is meaningless. True justice can only be delivered in a forum free from bias and conflict of interest. For cases where a state is a party, the Constitution explicitly names that forum the Supreme Court. Honoring that mandate is the only way to guarantee that every citizen gets what they are promised, not a guaranteed win, but a truly fair fight under the law. We began with a warning about what happens when good people do nothing. The story of Tanawa Downing's fight for justice is the story of someone refusing to do nothing. It is a courageous stand against a system that has, through a series of flawed judicial philosophies and a neglect of clear constitutional text, become fundamentally unfair. It is a call to correct a structural flaw that allows states to act as the dealer, player, and referee in a game where a citizen's liberty is on the line. This fight is not just for one person, it's for the integrity of the entire American legal system. The path forward requires us to embrace the principles championed by heroes like Justice John Marshall Harlan. We must insist that our Constitution is colorblind and more broadly class-blind. We must demand a government of laws, not of men, where the rights enshrined in our founding documents are not negotiable talking points but solid, unbreakable promises. This means restoring the vital protection of the grand jury indictment as a shield against prosecutorial overreach and insisting that the U.S. Supreme Court fulfill its constitutional duty as the neutral arbiter in all cases where a state is a party. This is not a partisan issue, it is a patriotic one. The call for truth, fairness, and equal application of the law is the very essence of the American ideal. It is a call to dismantle the legacy of decisions like Dred Scott and Plessy v. Ferguson, and to build a system that truly lives up to the promise of equal justice under law. It requires courage from citizens to speak up, from lawyers to challenge injustice, and from judges to have the humility and integrity to admit when the system has gone wrong and to set it right. The fight to remand these cases to the Supreme Court is a fight for the simple, radical idea that no one should be a judge in their own case. It is a demand that the rules of justice apply equally to everyone, including the government itself. The road is long, and the opposition is powerful, but the cause is just. The pursuit of a more perfect union depends on the willingness of people to stand up, as Tanawa Downing is doing, and demand that America live up to its highest ideals. Because justice, true justice, is never given. It must always be fought for.